Yeah, like.
Guys, we're fixing to be live.
Secretary or paralegal. Well, she's sweet one. She's all right. Look at that. No. But if you look around, hard enough, I'm sure you want to. It's going to cost me out. No, I tried. By now, yeah. The second one was before the charging. I didn't think it was been that. I had been. Oh, I had it. I saw it. Oh, no, I'm still here. Yeah. Okay.
All right, who do we have ready?
Your Honor, this is Stephen Leslie Foster.
All right, good afternoon, Mr. Foster. We are set for CR 21-214. Go ahead, Mr. Adams.
Thank you, Your Honor. Ms. Adams, on behalf of Mr. Foster, we're here for pretrial today. Your Honor, we file our standard operating procedure pretrial motions. We've got a global discovery motion, motion for jury to assess punishment, so on and so forth. However, I was just provided provided access today, I think, to the discovery materials in Mr. Foster's case. And so, of course, I need time to go through that and with Mr. Foster, and then visit with the state's attorneys about potential resolution, negotiated truce in this case. So at this time, not knowing what is in the discovery, I would ask the court's indulgence for one more pretrial setting, and perhaps we'll have things worked out by that time.
So you just got discovery today, you said? Are you talking about portal discovery, or are you talking about digital discovery, or what? I'm just trying to make sure we don't have an issue with lag time on, because usually we go from arraignment and then I set it for pretrial, and there's usually 30 or 45 days between there. But if we're not getting discovery, that's a concern for me.
Sure. No, it's the portal discovery, Your Honor. And I will point out, if it matters, I was appointed to represent Mr. Foster on two different charges. I have discovery in the other and the other one that's not on the court's docket today.
Right, any objection from the state on Mr. Adams' request for an additional pretrial?
No, Your Honor.
Court will set Mr. Foster then for pretrial on December 14th at 1:30 if he's in custody, 9 a.m. if he's on bail.
Your Honor, that's all I have on the afternoon docket at the, here at the jail. I know Ms. McMillan is, I won't comment any further. I need to visit with Ms. McMillan up at the courthouse for her plea hearing today.
Do you think she's here?
I think she should be there very shortly if she's not yet already.
Okay, we haven't seen anyone since we started, so,
I'm going to withhold comment.
okay.
Thank you.
I think your comments by my suspicion.
Yes, sir.
All right, do we have anyone else that's ready in the jail?
Yes, Your Honor. I've got Mr. Manning with, Mr. Morris.
CR 2086, State versus Christopher Eli Morris, set for plea.
Yes, Judge, we're here on a plea today. The judge going to read out the terms of plea bargain and the case is resolved.
Okay, let me make sure that I don't have it on this side. No, I don't see that I have any plea papers for Morris. So yes, if you'll go ahead and read me the terms.
Okay, Judge, he's going to be pleading to a possession of controlled substance penalty of 1 less than 1 gram, a state jail felony. The state at this point has agreed to abandon the punishment enhancements that had made that a second-degree felony. So we'll be going under state jail felony. Punishment's going to be assessed at 2 years TDC state jail, fine of $1,500, $180 restitution and DPS. And they're going to be taking into consideration cause numbers M19, 622, 623, 624, and 625.
Court cost $290.
Court costs are $290, reimbursement fee of $85, and he has total jail time credit of 560 days.
560,
That's correct, Judge.
and it's PCS less than 1.
That's correct.
Okay, Mr. Morris, I need you to raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. All right, Mr. Morris, make sure you speak up loudly and clearly so I can hear you on this end. Mr. Morris, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
Yes, sir.
Where your signature appears in the paperwork, is that your true and correct signature? And did you only sign it once you were satisfied that you understood what you were signing?
Yes, sir.
All right. Mr. Manning, do you believe your client to be competent today?
Yes, Judge.
And you've explained to him all of his legal rights?
I have.
And you believe he understands them?
He does.
All right, Mr. Morris, you heard Mr. Manning read the plea agreement to me. Is that your understanding of the plea agreement and what you're asking the court to approve today?
Yes, sir.
All right, so Mr. Morris, the range of punishment for a state jail felony offense of possession of controlled substance less than 1 gram is confinement in the state jail division of a state jail felony prison for not less than 6 months or more than 2 years, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
And I find here that the terms as read by Mr. Manning that would be a legal sentence of 2 years because it would fall within the minimum and maximum range. So understanding the range of punishment in the plea agreement, Mr. Morris, how do you plead to possession of a controlled substance, penalty group 1, less than 1 gram?
Guilty.
Are you pleading guilty because you're guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today? No? Okay, make sure you speak up because I'm having a hard time hearing you. All right, the court hereby accepts the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection, states one.
States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Mr. Woodwhacker, Ms. Heisel, one of you give me the facts to support the plea.
Yes, Judge, on the date in question, the Grand Slayton Police Department is on patrol and they observed a vehicle with a defective turn signal on a trailer, which I believe is a car hauler. As they come to a stop, the defendant steps out of his vehicle and false identifies as William Morris with a false date of birth. They begin having an interaction, and at one point in the interaction, the defendant attempts to get back into his vehicle against officers' wishes. They go to arrest him. He begins to resist arrest. He is tased. He then gives his real name of Christopher Eli Morris, who is the defendant, and the correct date of birth. When he is arrested, they pull out of his pocket a small bag of marijuana and a small bag of methamphetamine that they field weigh as 1.04 grams. The lab confirms as 0.22 grams net weight of methamphetamine.
All right, thank you. Any
Those
objection to that summary?
I was going to say, those are the cases that are being taken in consideration, as well as the case before the court at this time.
Thanks, sir. Any objection to that summary?
I had no objection, Judge.
All right, court will find that there is sufficient evidence to support this plea and convict the defendant. The court will follow the plea agreement in this case. Court hereby convicts Christopher Eli Morris of possession of controlled substance, penalty group 1, less than 1 gram. Court assesses his sentence at 2 years confinement in the Texas Department of Criminal Justice State Jail Division. Court will award him 560 days credit towards that sentence for the time that he has spent in jail on this charge. Court orders him to pay a $1,500 fine, $180 restitution, $290 court costs, and $85 reimbursement fees. Court also takes into consideration and dismisses unfiled misdemeanor cause numbers M19, 622, 623, 624, and 625. Mr. Morris, whenever you are released from the state jail prison, I'm going to order you to report to the Van Zandt County Courthouse and meet with a court compliance officer to make arrangements to pay off the fine, restitution, court costs, and reimbursements that you owe. Your failure to do so will result in the court issuing the warrant for your arrest, and we'll come back here and do this again. Do you understand?
Judge, if I may, also request, I don't know what the court's policy is on presumptive entitlement to diligent participation credit under 42A. I know some judges give it, some judges wait and have different procedures. Would you be willing to grant him diligent participation credit under 42A?
You're talking about at this time?
Yes, Judge.
No, what I do is I wait and I get a report from TDCJ electronically, and it tells me if there's any disciplinary history, including fights, failure to participate. They also send me reports about educational opportunities they're taking advantage of and things of that nature. So I wait to see how they do once they get into custody.
Okay. I will, is there a motion or would the court entertain a motion once he gets down there and once he gets settled? If we were to file a motion for diligent participation credit, would the court entertain that?
Yes, the court would entertain it. However, I am notified electronically at the correct statutory time by TDCJ. I log in the website, I go and it shows me all of the offenders that are eligible at that time and how many days they're eligible. And then it gives me an opportunity to review their progress.
Okay, but that's all the questions we have. Thank you, Judge.
All right, Mr. Morris, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with the bailiff to be fingerprinted. Good luck to you, sir. I'm ready when you are, bailiff.
All right, we do have Mr. Stevens with Mr. Simmons.
This is CR 2365, State versus Steve Leonard Simmons, and we are set for pretrial. Go ahead, Mr. Stevens.
Yes, Your Honor, we have no formal pretrial matter. We have received obviously all of our discovery, and I have received an offer from the state, which we're discussing with my client and going to do some more negotiations.
All right, there being no contested pretrial motions, the court will set Mr. Simmons for docket call, and we could set that either November 9th or we could set that on December 14th, Mr. Stevens. Which one would you prefer?
Judge, November the 9th is his birthday, but I'm not available November the 9th. So could we do the December date, Your Honor, that I said earlier this morning?
Okay.
I think you said December the 14th, sir.
Yes, court sets Mr. Simmons in for December 14th at 1:30 if he's in custody, 9 a.m. if he's on bail.
Oh, did you signature? Just in case.
All right, is this Mr. Derringer?
Yes, it is, Your Honor.
All right, this is CR 21-163 set for docket call. Go ahead, Mr. Stevens.
Yes, Your Honor. This morning, I received a new offer from Ms. Housel. I have, which was 4 years TDC. I discussed that with my client, and he does wish to accept that offer. So we would ask you, Your Honor, to set it for a plea.
Okay. You said the offer is 4 years TDC?
Yes, sir. I don't recall what the fine was, Your Honor, but 4-year TDC.
The fine on that would be 2,500.
And you said you're not available on the 9th.
No, sir, I'm not.
Will you be in my court this week on the 28th, on Thursday? It's an evidentiary day.
No, sir, I'm not. Actually, I got mediation that morning.
I hate to set it, it's not available on the 9th. The only other date that I have is December 14th. All right, we'll have to set Mr. Barrett then for plea on December 14th.
Thank you. Yes. Judge might be excused, sir.
Yes, thank you, Mr. Stevens.
Thank you, Judge. Yes, sir.
Your Honor, would we happen to have Ms. Thompson available? Because we do have Stacy Rash here in the room.
We do.
All right. Mr. Rash, come on up, man.
We have plea papers.
Yes, Your Honor.
State, do you have those?
Your Honor, Ms. Abraham came and got them from me.
Your Honor, I do have plea papers here, if that answers your question.
Okay, so you have them?
Yes, sir.
I don't have those.
You don't have a copy?
So I'm gonna ask you, Bailiff, you're gonna have to read those to me. So unless the state has a copy and can tell me what the terms are.
State. We have two different sets of plea paperwork, is that correct?
State, do y'all have the terms of the plea agreement?
Sorry, Judge, we're trying to pull it up, I believe. Yes, yes, Judge, I'm pulling them up right now. There are two charges. There's a possession of controlled substance penalty group 1 between 1 to 4 grams and a DWI second, a class A misdemeanor. The terms on the CR 21-00186 possession of controlled substance is a finding of guilt be deferred, punishment be assessed, 4 years community supervision, fine of $1,000, $180 restitution to the DPS lab, court costs of $290. I do not see Ms. Thompson's fees on this one. They must be on the DWI one. Look at that real quick.
The fee sheet attached to the plea paperwork.
The DWI, my computer would load. Punishment be assessed at 1 year in the county jail, probated for a period of 18 months, EMS trauma fine of $180, court costs of $270, reimbursement fees of $15. I don't see, maybe there's a special finding on one of them that for Ms. Thompson's fees. Deputy McLeish, do you see on one of them a reimbursement for Ms. Thompson's fees? If not, we'll need to get that added.
Yes, sir.
Okay, would you tell the court what that is?
It looks like it's $750 for the plea and an additional $150 for the 1245s and multiple felony.
So 900 total.
Yes, Your Honor.
What are the 1245s? No one mentioned the 1245 to me.
Well, Ms. Thompson can speak up, obviously, if I'm making a mistake here, but somebody has circled the option of additional 150 for the 1245s and multiple felony. Would you like me to put this up in front of the camera?
No, it's okay. Ms. Thompson can.
Your Honor, this is Ms. Thompson, Your Honor. I believe that I circled that by mistake. I may need to resubmit that bill. I think it's $75 since that DWI is actually a misdemeanor.
Okay, so it should be $750 for the third degree felony and then $75 for, but the $75 wouldn't be for a 1245 misdemeanor because she's actually pleading out on it, right?
That's correct. But that's all I should be charging, I think, anyways, for that one.
All right, I'll tell you what, hold on just a second. I've got to go pull the form.
Mr. True, does she need to fill out?
I have one.
Okay, just. Oh, no.
Okay. All right. So, so that does appear to be correct. So it would be 70, Ms. Thompson, you're right, $75 for the misdemeanor and then $750 for the third degree for a total of $825. Okay.
Correct, Your Honor.
All right, Ms. Rash, if you will, ma'am, please raise your right hand. I'm going to place you under oath. Ms. Rash, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, let me put you down. You're going to have to speak up a lot louder because either you're soft-spoken or I just can't hear, but it's very important that I hear what you have to say. And my court reporter here, she's trying to take down what you say, okay?
Yes, sir.
All right, that's better. All right, Ms. Rash, your name is Stacy Lynn Rash, is that right?
Yes, sir.
Ms. Rash, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Ms. Ann Thompson. Are you pleased with her representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with her and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And when you signed the paperwork, did you only sign once you were satisfied that you understood everything you were signing?
Yes, Your Honor.
And you signed with your true and correct signature?
Yes.
All right, and you heard Ms. Thompson read what the plea agreement was in each one of these cases. Is that your understanding of the plea agreement?
Yes, sir.
Well, rather, I think Mr. Woodwike read it, but you heard Ms. Thompson also talk about the attorney fees. Is that right?
Yes, sir.
All right, so Ms. Rash, in your felony case, possession of a controlled substance in penalty group 1 between 1 gram and 4 grams, that is a third-degree felony offense. And that does carry a potential punishment range of not less than 2 years and more than 10 years confinement in the Texas Department of Criminal Justice and a $10,000 fine. If the court approved the agreement today and placed you on community supervision, if you violate that community supervision, the court in another hearing could revoke your community supervision, convict you of that offense, and the court would be able to assess your punishment anywhere within that range from a minimum of 2 all the way to a maximum of 10 years in prison. Do you understand that?
Yes, sir.
All right, and then the misdemeanor cause number, you're charged with a second-degree offense or a class A misdemeanor offense of driving while intoxicated, second or more. That carries a range of punishment as a class A misdemeanor between 0 days to a maximum of 365 days and a fine of not more than $4,000. Do you understand that?
Your Honor.
All right, so under the agreement and the range of punishment, Ms. Rash, how do you plead to possession of controlled substance in penalty group 1?
Yes.
How do you plead to driving while intoxicated, second offense?
Yes.
Are you pleading guilty to each of those crimes because it is true that you committed each of those crimes?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to either crime today? All right, court will accept the defendant's plea of guilt at this time. Ms. Thompson, any objection to the state's evidence?
No objection, Your Honor.
All right, state's evidence is admitted in each cause as State's Exhibit 1. And the court will take judicial notice of Ms. Rash's judicial confession. State, can you give me the facts to support the plea at this time?
Yes, Judge, on the date in question, March 13th of this year, the Van Zandt County Sheriff's Deputy and a game warden observed the defendant almost strike another vehicle while traveling down FM 17 near I-20. They make contact with Miss Rash. They believe that she is possibly intoxicated and call out a DPS trooper. When the trooper arrives, the defendant states to him that she is drunk and that he should just take her to jail. He places her through standardized field sobriety testing, of which she is 6 of 6 on HGN, 4 of 8 on walk and turn, and 3 of 4 on one leg stand. She is arrested for DWI, and while she is being patted down on her way to be arrested, they find a baggie of methamphetamine in her purse. When she gets to the jail, she provides breath specimens of a 0.18 and a, whoa, I just lost it. 0.180 and 0.183. The lab tests the bag of suspected methamphetamine. It is methamphetamine, comes out at 3.8 grams of meth.
Thank you, Ms. Thompson, any objection to that summary?
I do not have any objection to it, Your Honor.
All right, court will find based on the evidence presented that there is sufficient evidence to convict Ms. Rash of each of these offenses. Court will follow the plea agreement in each case. With regards to possession of controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams, the court will defer a finding of guilt for Ms. Rash. Court will place her on 4 years community supervision. Court will order her to pay a $1,000 fine, $180 restitution, $290 court costs. Court will also order her to pay reimbursement fees of $825. In the offense of driving while intoxicated second, Class A misdemeanor, the court will follow the plea agreement, assess her punishment at 1 year confinement in the Van Zandt County Jail, will suspend that sentence and place her on 18 months community supervision. Court will order her to pay a $180 fine, I'm sorry, a $180 restitution. No, that's correct. Is that not right, Mr. Woodwike? It's fine. It's EMS fine, correct?
Yes, Judge. It's the $100 EMS trauma fine. Yes, Judge.
And a zero fine on that charge. Is that correct?
Zero other than that EMS trauma fine. Yes, Judge.
All right. Court will order $180 fine, $270 court cost, and $15 reimbursement fee. Now, with regards to any condition of community supervision towards her incarceration, she would have credit for that time. Is that correct, Mr. Woodwike? Or Ms.
I believe so, Judge.
Ms. Rash, how long have you been in custody?
2 weeks.
2 weeks?
2 weeks.
I don't recall what the statutory requirement is as a condition of community supervision for DWI second. It may be 10 days.
She's been in jail since October the 12th, Your Honor.
Is it 14 days as a condition of probation? Oh. Look at how many, how long? Woodwalk, have you found it yet?
Yes, Judge, the minimum on DWI second is 30 days. Now, I'm aware that she had some time in Henderson County. I believe she has some time as well beyond just the time that she spent in Van Zandt County. I am unaware as to the total amount that Ms. Abney was able to find in the judgment if the bailiff would take a look at that and see what kind of credit in the judgments we have given her, if any. If not, we may need to look into that and review the amount of time that Ms. Rash has. My understanding was it was in excess of 30 days, so we were not going to.
What section is that, Mr. Woodwalk?
It's 4904, 4909, Judge. Enhanced punishment for extra DWI.
It has the minimum term listed there.
Yes, Judge. Let me just enhanced offenses and penalties, Section A. An offense under this section is a Class A misdemeanor with a minimum term of confinement of 30 days. It is shown on the trial that the person has previously been convicted one time of an offense regarding DWI operating a watercraft or amusement park while intoxicated. Amusement park ride while intoxicated. So we may need to calculate how much back time she has. My understanding was that she had an excess. I thought that would be included, but perhaps not.
Is that on condition of community supervision or on being sentenced?
It just says the minimum term of confinement is. I don't.
Yeah, I think that's on the trial of the offense, though. I'm looking for the
That's
community supervision, which should be in 42A.
That'd be in 42A, yes, Judge.
I've not found that yet. Ms. Thompson, jump in if you know the section.
I'm trying to reach the Henderson County Jail right now to try to talk to them, Your Honor.
Okay.
It's 401 through 408, Judge. Not less than 5 days of confinement in county jail if the defendant was punished under 4909A. So it's 5 days in jail.
So an A and then 1 is for DWI 1, and then A2 is second.
Yes, Judge. So 5 days, which she has more than that of credit just in our time. Yeah. I know 30 days is the minimum confinement. We don't do a lot of those up here, so.
All right, so at some point, the conditions of community supervision need to be, they need to reflect that I'm going to order her to do 5 days in jail as a condition of community supervision, and I'm going to give her credit towards those 5 days for any of the 5 days that she has served, so that we can make sure that the sentence in the judgment complies with the law. So, Ms. Rash, you don't have to serve an additional 5 days, but at some point, the paperwork needs to be fixed to show that you're being ordered as a condition of your probation to do 5 days in jail. So that means that if you were subsequently revoked off your community supervision and sentenced, you would not get credit for those 5 days because the law requires you to do those as a condition of your community supervision. Do you understand? Okay. All right. So Ms. Rash, the court on the DWI orders you sentenced to 1 year confinement in the county jail, suspended for 18 months. Court will order you to serve 5 days in jail as a condition of community supervision. The court will give you credit for 5 days towards that condition of your community supervision as already served. Order you to pay the fine of $180, court costs of $270, and $15 reimbursement fee. Mr. Rash, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you get fingerprinted by the bailiff there. After that, speak with the probation department. Officer Matura is there, and she can give you information about the next step, okay?
Yes, Your Honor.
Ms. Ventura, you do.
She should be, she's already.
Mr. Brady, you put the bishop.
Excused?
Yes, thank you, Ms. Thompson. All right, this is cause number 18337, State versus Rochelle Renee Shelton, set for a plea.
That's correct, Judge, and we're ready to proceed. If you'd like, I can read you the terms.
Yes, sir. I was making sure I don't have them here. I don't, so go ahead.
Ms. Shelton has been charged with possession of controlled substance less than a gram. That's in penalty group 1. She was charged by indictment under 48 or 481, 115 of the Health and Safety Code. Date of offense, June 11th, 2017. For proceedings to plead 2 years, TDC probated for 2 years, fine of $1,000, $180 restitution. There's $209 court cost and $585 reimbursement.
Okay, thank you, sir. Ms. Shelton, if you'll raise your right hand. Ms. Shelton, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, you may put your hand down. Your name is Rochelle Renee Shelton, is that right?
Yes, Your Honor.
And Ms. Shelton, are you a United States citizen?
Yes,
Do you read, write, and speak English?
yes, Your Honor.
Have you ever been diagnosed with a mental condition?
No, Your Honor.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Absolutely.
Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, Your Honor. I fully understand.
And where you signed the paperwork, is that your true and correct signature?
Yes, sir.
Mr. Manning, do you believe Ms. Shelton to be competent today?
She is, Judge.
And you explained to her her legal and constitutional rights?
I have, Judge.
And you believe that she understands those as well?
She does.
Ms. Shelton, you heard your attorney, Mr. Manning, read to me what the plea agreement is in this case. Is that your understanding?
Yes, Your Honor.
All right, so Ms. Shelton, the range of punishment for a state jail felony offense is a minimum of 6 months to a maximum of 2 years and a fine not to exceed $10,000. And I see the plea agreement fits within that range of punishment of 2 years suspended and you being placed on probation for 2 years. So that means your sentence, if I approve it today, your sentence would be the maximum 2 years in prison. You understand that?
Yes, Your Honor.
And that would be suspended and you'd be placed on probation for 2 years. And if you violate the terms and conditions of your probation, the state of Texas, through their attorneys, could file a motion and bring you back before the court. And if they prove that to me, the court could then revoke your community supervision or probation, and could assess your punishment at 2 years confinement in prison. You understand that?
Yes, Your Honor.
Okay. Understanding those things, how do you plead to possession of controlled substance, penalty group 1, less than 1 gram?
Guilty.
And are you pleading guilty because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
All right, court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to states one.
All right, states 1 is admitted, and the court takes judicial notice of the defendant's judicial confession. The state will go ahead and give me the facts to support the plea.
Yes, Your Honor. On the date in question, Ms. Shelton was the passenger of a vehicle pulled over for an obstructed license plate that made it unreadable. Both Ms. Shelton and the driver of that vehicle were acting extremely nervous. The driver admitted to the officers that he had K2 on his person and additional drug paraphernalia in the vehicle. Officers got both Ms. Shelton and the driver out so that they could conduct a probable cause search of the vehicle. They did locate additional drug paraphernalia as well as a bag of suspected methamphetamine in Ms. Shelton's purse in the passenger side floorboard. They sent that off to the lab, and the lab did confirm it was 0.55 grams of methamphetamine.
Thank you, Ms. Heisel. Any objection to that summary, Mr. Manning?
Objection, Judge.
All right, if there's nothing further, then the court will find that there is sufficient evidence to convict Ms. Shelton of this offense. Court will follow the plea agreement in this case. Court finds her guilty of possession of a controlled substance of penalty group 1, less than 1 gram. Court will assess her punishment at 2 years confinement in the state jail division of TDC. The court will suspend that sentence today and place her on community supervision for 2 years. Order her to pay a $1,000 fine, $180 restitution, $290 court costs, and $585 fees. Ms. Shelton, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you be fingerprinted with a bailiff, and then you'll report to the probation officer.
Thank you, Your Honor.
You're welcome. Good luck.
Judge, I believe that concludes my business. May I please be excused?
Yes, and Mr. Manning, you still haven't heard anything from Mr. Richardson from this morning, correct?
I have not, Judge.
Okay, thank you, sir.
Thank you.
Your Honor, do we have Mr. Weiner available?
We do.
All right, Mr. Burke, step up, please.
Good afternoon, Mr. Weiner.
Making sure I was unmuted. Good afternoon, Judge.
All right, this is cause number CR 27-8, State versus Jeffrey Daniel Furr, set for pretrial.
Yes, Your Honor. I'm going to ask for a reset on this pretrial. My client was recently arrested on some greater level offenses. I've met with him in the jail in the meantime. I've spoken with Ms. Heisel at the DA's office. They do not have the new charges yet. And I don't want to do this for 6 months. And I understand the court's position typically on something like this, but I'd like to see if we could have a 30-day reset if they're able to get the new cases. Though I haven't been retained on them, Mr. Furr has indicated he's going to try to, but even if I'm not his lawyer on that, it seems like for the sake of judicial economy, it makes sense to kind of have everything we're working with all at once, Judge.
Do you have any contested pretrial motions in this cause number?
Not at this time, Judge.
Okay, so what I would prefer to do is move past pretrial in this case and just set it for docket call, and then I can give you time to let the other cases come in and catch up if you have no objection to that.
That sounds very appropriate, Judge. Thank you.
Okay, so there being no contested pretrials, the court will set Mr. Furr for docket call. Are you available on December 14th, Mr. Weiner?
Let me pull up my calendar right here. December. Yes, Your Honor. I'll be available at 1:30 December 14th.
Okay, December 14th, we'll set it for docket call at 1:30.
Thank you very much.
Thank you, Mr. Weiner.
That's all I have. May I be excused?
Yes, sir. Good to see you.
Good to see you.
Mr. Ashmore, do you need some more time?
I do, just a few minutes.
Okay, very good. Your Honor,
Yes, ma'am.
I'm sorry, it appears that we're down to just two attorneys, Ms. Beasley, who is actively working with her many clients, and Mr. Ashmore needs just a few more minutes. So can I let you know when they're ready?
Yes.
Thank you, sir.
Ms. Heisel?
Yes, Your Honor.
On Mr. Ogletree, is there going to be an agreed protective order today?
Yes, Your Honor, and Ms. Beasley has the signed copy from the state on that at the jail with her. So she has that to submit with the plea paperwork.
Okay, so she has the order.
Yes, Your Honor.
Okay, and do you know if he was served with that today?
I'm sorry.
Do you know if he was served with that application?
Your Honor, I did give her a copy to show him. I don't know that the clerk's office gave him a copy to keep, but we can make sure that that gets sent over to Ms. Beasley so that he has a copy for his records.
Okay, we'll do that. I appreciate it. All right, and Mr. Adams, no response on Ms. McMillan.
Your Honor, I called Ms. McMillan shortly before noon today. She told me that she had left and was on her way, but at that time she was only approved. Which is a gesture.
About 3 o'clock. So you want to wait a little bit longer?
I don't want to.
Are you willing to wait a little bit longer?
Um,
Okay. Well, and I'm assuming that if this is a plea agreement, y'all haven't gone over the plea papers and all that stuff yet.
That's correct. I would just spitballing his plea for time. She could start her time in the Van County Jail as well as she could anywhere else while waiting for a reset plea.
She said 3 o'clock. We'll give her 30 minutes. If she's not here in 30 minutes, then I'll cut you loose and we'll deal with her when she gets here, if she gets here. If we need to go send out a search party, we can do that too.
Yes, sir.
All right, she said Ashmore is ready.
Yeah, Mr. Schroeder, come on up, sir, please.
All right, who are we going on first?
Mr. Schroeder, Your Honor.
All right, this is cause number CR 2310 and CR 213738 and CR 21242. State versus Dylan Andrew Schroeder set for docket call on all cases. Go ahead, Mr. Ashmore.
Judge, I appreciate the opportunity for a docket call with Mr. Schroeder. We have a new offer today extended by the district attorney, which is 10 years TDC institutional division on the bail jumping charge, 1245 all other charges. My client is not inclined to accept that. I would request another docket call since I am lawyer number 2 on this case and still is somewhat new to me, so we can discuss this offer and just come back, even if it's on a quick turnaround, Your Honor.
State.
State has no objection to resetting it to the 9th if Mr. Ashmore is available. I do know this is, like he said, relatively new to him. However, I believe that's the state's best offer in this case. So I think setting it out further than that probably ain't going to get us anywhere.
Are you available on November 9th?
Yes, Judge.
Okay, court set Mr. Schroeder for a final docket call on November 9th.
Thank you, Your Honor.
Mr. Schroeder, just so you're aware, if November 9th comes and goes and there's no agreement, and I'm not saying that you have to reach an agreement, but there will be no agreements after November 9th. So I want you and the state to get to your best offers and let me know what we're gonna do on the 9th.
Yes, sir, Mr. President. Yes, sir. Have a seat, picture. It's yours. Thank you. And we're ready on Mr. Poche, Your Honor.
Poche, CR 2353 for arraignment. Go ahead, Mr. Ashmore.
I need just a second to get to his case. Sorry, I was in Mr. Poche's case, Your Honor. Judge, Mr. Poche has confirmed that his name is spelled correctly in the indictment. Both places, Francois Poche, excuse me. And he understands the nature of the charge against him, which is a health and safety code violation, in possession of tetrahydrocannabinol, if I said that right, I hope so, in amount less than 1 gram. We have in the discovery pack we just received from the state a very old offer that was extended before I was his attorney for 6 months state jail. I don't know if that's expired. I'm working with the state on that, but he's authorized me to enter a plea of not guilty and work with the state to resolve this matter. He's also a combat veteran from Afghanistan, served honorably in the United States Army. So we may be approaching the court again on some other deferred probation similar to this morning later, Your Honor. So I'm going to ask for just reset us for a pretrial so I can work with the state, please.
All right, the court will enter Mr. Poche's plea of not guilty into the record, find that he's waived the formal requirements of arraignment, set him for pretrial on December 14th. All cases, Mr. Poche, will be at 1:30 if you're in jail. If you make bond in this case, your hearings will be at 9 AM in the courthouse.
Yes, sir. Thank you.
You're welcome, sir.
That's it for me. May I be excused, Your Honor?
Yes, sir. Thank you, Mr. Ashmore. Good to see you.
Good to see you. Thank you, Judge.
All right, Ms. Beasley, need some more time?
Yes, Your Honor. I believe she's working with her last client, but she is still working with them.
Hey, no problem. Tell her to take her time and do what she needs to do.
Thank you, sir.
All right, thank you, ma'am.
Your Honor, are you available?
Yes, ma'am.
You're good. Ms. Beasley's ready.
All right, Ms. Beasley, who do you want first?
Mr. Turner, Craig Turner.
All right, Mr. Turner, come on forward, please. All right, Mr. Turner, this is cause number CR 21-194 and 195. I'm gonna have you raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir.
All right, you may put your hand down. Make sure you speak up loudly and clearly. Your name is Craig Allen Turner, is that right?
Yes, sir, it is.
And Mr. Turner, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition? No?
Yes, sir.
Okay, make sure you speak up. And Mr. Turner, in this case, you're represented by your attorney, Ms. Deborah Beasley. Are you pleased with her representation of you?
Yes, sir, I am.
Feel like you've had enough time to discuss your cases with her and have all your legal questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, I understand everything.
Okay, and where you sign, that is your true and correct signature. Is that correct?
Yes, sir.
Ms. Beasley, do you believe Mr. Turner to be competent today?
Yes, Your Honor, I do.
And you've explained to him his legal and constitutional rights?
Yes, Your Honor. He's indicated he understands everything.
All right, Mr. Turner, in cause number CR 21-194, you are charged by indictment with a felony offense of possession of controlled substance, penalty group 1, greater than or equal to 400 grams. What is the range of punishment? It's not indicated on the judgment here, state, what, or Ms. Beasley, either one of you. What is the range of punishment for Mr. Turner on this felony charge?
Judge, that is 5 to 99 or life and up to a $50,000 fine. It is above, it's undefined. It's outside the first degree punishment range, but it follows the first degree punishment range for incarceration.
5 to 99 or life and a 50,000?
Up to a $50,000 fine, yes, Judge.
All right, so Mr. Turner, in that cause, the range of punishment is if you are convicted and sentenced by either a court or a jury, would be in the range of a minimum of 5 years confinement in the Texas Department of Criminal Justice up to a maximum of 99 years or life imprisonment and a fine not to exceed $50,000. Do you understand that full range of punishment?
Yes, sir, I do.
And I see the plea agreement in this case is that you would be pleading guilty to that charge in exchange for the state's recommendation that you be convicted of that offense, sentenced to 10 years confinement in prison, with that sentence being suspended and you being placed on community supervision or probation for 8 years with a fine of $3,500, $180 restitution, reimbursement fees of $1,320, court cost of $290. And the state would be dismissing CR 21-195, which is your tampering charge. And as a condition of your probation, you would be ordered to attend the substance abuse felony punishment facility. Is that your understanding of the plea agreement and what you want the court to approve?
Yes, sir, it is.
And before I go forward with this, if I approve it and order you to go to safety, are you willing to go to the substance abuse felony punishment facility with an attitude of accepting the resources and rehabilitation services that they're willing to offer?
Yes, sir, I am.
Okay, what I want to assure is that you're not going down there just because it's a part of probation. I only want to send people down there that are willing to go to better themselves.
Yes, sir, it is.
Okay. All right, and so I guess let me ask you at the time, Mr. Turner, how do you plead to possession of a controlled substance in penalty group 1 greater than or equal to 400 grams?
Guilty.
And Mr. Turner, are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Ms. Beasley, any objection to the state's evidence?
There is no objection, Your Honor. And just to let the court know, in the state, while I've been at the jail, I was notified
that by transport, that they were notified by the Kaufman County Jail that my client has a misdemeanor pending in Smith County. It is a misdemeanor, Judge. Safety will not accept him until he takes care of everything. So we still want to proceed with the plea today, but work with the court and the DA's office to get him sent over to Smith County so that they can take care of the case over there, and then we can get him back here and then get him on the list for safe pay.
Okay,
Judge, I'd state would be willing to contact Smith County District Attorney's Office, see if we can expedite that process for Mr. Turner.
thank you. All right, State, can you give me the facts to support the plea?
Yes, Judge. On the date in question, which is January 12th of this year, the Canton Police Department sees a vehicle that the defendant is driving make what they believe to be clearly evasive turns to lose the officer, even though the officer is not actually following him. Because of this, the officer runs the paper tag on the vehicle and comes back with no return to be fictitious. Canton Police Department makes contact with the defendant. He states he does not have an ID, but he's going from Maybank to Garland, but he's in Canton, which doesn't make sense to the officer. The officer asks for consent to search, and the defendant grants consent. The officer finds scales with a crystal-like substance on it, and inside of a styrofoam big gulp cup, he finds a baggie floating in the liquid inside. The lab tests the entire container of soda. It comes back at 650.97 grams of meth. Also of note is before and during the stop, the defendant is calling 911, calling in other disturbances at other locations, I believe, to see if he can get the officer to respond to those and stop investigating him. So that is the tampering with evidence and the possession of controlled substance greater than 400 grams charges.
Any objections?
No, Your Honor.
All right, then based on the evidence, the court will find that there is sufficient evidence to convict Mr. Turner. The court will follow the plea agreement in this case. Court hereby convicts Craig Allen Turner of possession of controlled substance, penalty group 1, greater than or equal to 400 grams. Court will assess this punishment at 10 years confinement in the Texas Department of Criminal Justice. Court will suspend his sentence today and place him on community supervision for 8 years. Order him to pay a $3,500 fine, $180 restitution, reimbursement fees of $1,320, court costs of $290, and the court will dismiss under section 1245, cause number CR 21195, tampering or fabricating with physical evidence. Mr. Turner, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you be fingerprinted by the bailiff, and then you'll talk with the probation officer for more information.
Yes, sir.
Mr. Turner?
All right, who are you ready on now?
Mr. Booker, Christopher Booker, Your Honor.
Christopher Glenn Booker, CR 2105, motion to revoke. Go ahead.
Your Honor, we've been able to come to a resolution with Ms. Curry in regards to this case. I'd ask that it be set on the next available court docket for a plea.
We could, the very next available is an evidentiary docket on Thursday, day after tomorrow. Otherwise, it would be November 9th.
We would prefer Thursday, Your Honor.
Okay, and will it be for time or for probation?
Time, Judge.
Okay, all right, then I will set it for Thursday, October 28th. And that will be at 1:30.
Thank you, Judge. May he be excused?
Yes, ma'am. We'll see you on Thursday, Mr. Booker. You're welcome. Who are we ready on?
Miss Fowler from this morning, Judge.
Kimberly Fowler, CR 19-214.
Yes, Your Honor.
All right, Ms. Fowler, raise your right hand. I'm going to place you under oath. Ms. Fowler, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. All right, Ms. Fowler. You appeared before the court previously to on August 13th of 2019 on the charge of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams, a second-degree felony offense. On that date, the court heard the evidence, found that there was sufficient evidence to convict you. However, the court followed a plea agreement, deferred a finding of guilt, placed you on community supervision for a period of 10 years. And it was during that period that the state filed its motion to adjudicate and revoke. And they filed that on August 26th of 2021. Have you had sufficient time to review that with your attorney, Ms. Deborah Beasley? Okay. And are you pleased with Ms. Beasley's representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with her and have your legal questions answered?
Yes, sir.
Ms. Beasley, does your client waive the formal reading of the state's motion?
She does, Your Honor.
And is it her intent to plead true to all 8 counts as alleged?
Your Honor, there is one count that is a duplicate in the state's motion. I believe that is count 7 that I believe the state has agreed to waive because it's simply a duplication.
So 6 and 7 are the same?
I think it's not 6 and 7, it's
5 and 7 maybe.
5 and 7.
Okay, so the state, so she's pleading not true to count 7.
Yes, sir, since it's a duplication.
All right, and I do want to go ahead and put on the record that this morning, Ms. Fowler appeared in court and requested that her case be reset for entering a plea agreement after the holidays, and the court did conduct a urinalysis exam of Ms. Fowler, to which we received testimony on regarding the instant test coming back positive for methamphetamine. Ms. Beasley, have you any concerns that Ms. Fowler is currently under the degree or under the influence of any illegal substance or prescription substance that causes her to not be competent in your mind?
No, sir. I was her attorney before she was placed on probation, and I dealt with her quite a bit during the first representation. I'm now her attorney on this, and I have no problems communicating with her. In fact, her communication skills and everything in respect to this case are a lot better than they were previously. She's improved greatly from the previous representation. She understands, she's made logical questions. I believe she totally understands what we're doing here today.
Thank you, Ms. Beasley. All right, Ms. Fowler, at this time, I'm going to ask you then, ma'am, how do you plead to counts 1, 2, 3, 4, 5, 6, and 8? Are those counts true or not true? And Ms. Fowler, are you pleading true to those counts because of the conduct alleged in those counts are true or is true?
Sure.
Has anyone threatened, forced, or pressured you to plead true to any of these counts?
No.
All right, the court will accept the defendant's pleas of true. Ms. Beasley, any objection to the state's evidence?
No, Your Honor.
All right, state's evidence is admitted as State's Exhibit A, that being the defendant's waiver of rights and plea of true to state's motion to adjudicate. Anything further from the state?
No, Your Honor.
Anything further from the defense, Ms. Beasley?
No, Your Honor.
All right, then based on the evidence presented, the court will find that Ms. Fowler has violated the terms and conditions of her community supervision. Court will find counts 1 through 6 to be true and count 8 to be true. Court will follow the plea agreement in her case. Court will this date adjudicate her guilty of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 1 gram, less than 4 grams. Court will revoke her community supervision and assess her punishment at 2 years confinement in the Texas Department of Criminal Justice Institutional Division. Order her to pay the balance of her fine and court costs and any other financial obligations. Court will award her 431 days credit towards her sentence for the time that she has spent in jail on this cause previously. Ms. Fowler, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Once you are released from the Texas Department of Criminal Justice, if you've not paid off all of your fines and court costs and fees, I'm going to order that you report to the Van Zandt County Courthouse so that you can make arrangements to pay those things, and your failure to do so will result in the court issuing another warrant for your arrest. Okay. All right. Good luck to you. I'm gonna have you go with the bailiff. All right, who do you have with you now, Ms. Beasley?
Want to go for, Your Honor?
All right, cause number CR 19-174, State versus Wanda L. Goforth, and we are set for plea today. Ms. Goforth, if you'll raise your right hand, place you under oath. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. I don't know if it's internet connection, but I can't really hear you, so make sure you speak up, okay?
Okay.
Thank you. Ms. Goforth, you appeared before the court on October 22nd of 2019. And you pled guilty to the 3rd-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 grams, but less than 4 grams. The court heard the evidence, found there was enough evidence to convict you, but the court followed a plea agreement on that date and deferred a finding of guilt and placed you on community supervision for 4 years and ordered you to pay a $1,250 fine. It was during your period of community supervision that the state filed its motion to adjudicate and revoke on April 29th, 2021. Have you had an opportunity to review that with your attorney, Ms. Debbie Beasley? And do you believe you've had enough time to discuss your case with her and get all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Are you pleased with her representation of you?
I am, sir.
Ms. Beasley, does your client waive the formal reading of state's motion?
Yes, Your Honor.
Is it her intent to plead true to all 8 counts in this agreement?
Yes, Your Honor.
All right, Ms. Goforth, this time I'm going to ask you, how do you plead to counts 1 through 8 as contained in the state's motion? Are those counts true or not true?
True, Your Honor.
And Ms. Goforth, are you telling me that those counts are true because in fact they are true?
Yes, sir.
Has anyone threatened or forced you or pressured you to plead true to any of these counts today?
No, sir.
All right. Court will accept Ms. Goforth's plea of true at this time. Ms. Beasley, any objection to the admission of the defendant's reserved rights and plea of true?
No, Your Honor.
All right. That document is admitted as State's Exhibit A. Court will take judicial notice of Ms. Goforth's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close in this matter.
Anything further from the defense?
No, Your Honor. Rest and close.
All right, the court, based on the evidence, finds that Ms. Wanda L. Goforth has violated her community supervision. Court finds all counts alleged in the state's motion to be true. Based on that, the court hereby adjudicates her guilt, finds her guilty of possession of controlled substance in penalty group 1, greater than or equal to 1 gram but less than 4 grams. Court revokes her community supervision and assesses her punishment at 2 years confinement in the state jail. 2 years confinement in the Texas Department of Criminal Justice Institutional Division, and orders her to pay the balance of her financial obligations, including fine, court costs, and restitution. Court awards Ms. Goforth 185 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Goforth, just like I told the other lady, once you get out of TDC, if you've not paid off the money that you owe, I'm going to order you to report to the Van Zandt County Courthouse to make a payment arrangement to discharge those things. Failure to do so or failure to abide by the payment plan will result in the court issuing a warrant for your arrest. Do you understand?
Yes, sir.
Okay. All right, Ms. Goforth, I'm gonna have you go with the bailiff to be fingerprinted. Go like you, ma'am.
Thank you.
You're welcome. All right, is this Mr. Walker?
This is, Your Honor.
All right, this is cause number CR 2200 and 232. And I believe we're set for status today.
That is correct. We're waiting for the co-defendant to take care of her case, Courtney Odom, Your Honor.
I'm trying to recall if, I think we have her set for a,
She's specially set in 2022, Judge. I don't remember the exact date.
It's in February, Judge. I don't know what date.
okay. All right, so do you want, I hate to set Mr. Walker that far out without, I always want to make sure that if there's a status update or anything that I need to be aware of, or if Mr. Walker has any concerns that I need to address. If there's no, if council doesn't have concern about that, and Ms. Beasley, understanding that you will no longer be practicing in this county in 2022, correct?
That is correct, Judge, but I have talked with my client. I've explained to him, he understands that. But I've also told him in the next few weeks, I want to come back to him, even though we've already gone over all of the discovery in his case. Initially, when I was appointed, he understands that another attorney will represent him and help resolve the case. But I'm going to be coming and visiting him at the jail and going back all over that information as much as I can so that he's in the best possible position when he gets the new lawyer.
Let's do this. Let's set him on December 14th.
Okay.
We'll do it for a status, and we will appoint new counsel on that day and give you an opportunity to hand over the discovery and other things and bring that attorney up to speed so that Mr. Walker doesn't lose any continuity of representation between December and the ultimate trial date. And then in December, we'll set him for a date closer to the co-defendant resolving her case.
Yes, Your Honor.
So we'll set that for status on December 14th for appointment of new counsel. And who represents the co-defendant? That's Mr. Manning, correct?
Mr. Manning.
That's Jonathan Manning, yes, Judge.
Okay. You understand what we're doing, Mr. Walker?
Yes, sir.
Okay.
And that'll be at 1:30, correct, Judge?
That'll be at 1:30. Yes, ma'am. Ms. Beasley, before we call it the next case, maybe we should review your cases and any other case similar to Mr. Walker's that, and maybe Mr. Ellis or whoever, that's going to have a level of complexity where a lot of information needs to be passed on. Perhaps we look at getting those cases set for the 14th also. So maybe if you can contact Ms. Abraham and let her know which cases you think would be similar, that would benefit from you two attorneys passing the torch and exchanging discovery and getting everything up to speed.
I will, Judge. In fact, if we could talk about Mr. Ellis next, I've got
Yeah.
some.
Is he in the room?
Yes, Your Honor.
All right, come on up, Mr. Ellis. This is cause number CR 19305, State versus Donald Brian Ellis. Go ahead, Ms. Beasley.
Your Honor, I visited with Mr. Ellis yesterday. He asked a question that I need a chance to contact the DNA expert that the court's already previously provided. So I'm going to do that. He understands that there will be another attorney that will be appointed to finalize his case. But in addition, I know there's going to be some time the next few weeks. I still want to work and try to do as much work as I can to help him on his case. I've already spoken with Ms. Curry. There is a question that came up yesterday that was a unique question. And I'm going to be filing a motion with the court to ask for a second expert. It's a medical expert. I won't need a lot of funds. I'm going to probably be asking for $500 so that I can ask that medical question and have that answered for him. And I'd like to get that done before I get off this case.
Okay, well then let's set him also on 12/14. I'll give you time to do that.
Thank you, Judge.
And then we'll assign new counsel that day, if there's anyone left for Mr. Ellis.
I understand, Judge.
I mean, I'm not being facetious. My will may be, I may not have anyone on the will that can take his case that hasn't already been on it.
I understand. Judge, could I have just a moment to talk to him before he's taken back? We only have one other client that's left.
Sure, that's
and that will
fine.
be a plea.
Sure,
Just a couple minutes.
sure.
Judge, could you join the state in a breakout room? Is that possible?
Yes, ma'am, we'll do.
Yes, ma'am. So come on.
believe.
36 years. Oh, wow.
So it's not just, you're not practicing in this county, you're retired.
I've got more cases in there that I have in Kaufman that still have to finish up. And so I have to finish up there, but yeah, it's gonna take a little bit over there because I have lots of cases over there. But yeah. Thank
Good for you.
you. No, because I love working with y'all.
Well, then stay.
I was wondering while we were getting dumped. No, believe me. Y'all been the best part of it.
All right, Ms. Beasley, are you ready on Mr. Ogletree?
I am, Judge.
All right, this is cause number CR 21-136 and CR 21-182, State versus Philip Andrew Ogletree. And I believe that both cases are set for pre-trial, and then I had indication that perhaps we had a plea today. Is that correct?
That is correct, Judge. We have been able to resolve this case. We've got the final agreement made yesterday afternoon.
Okay. And what case will he be pleading on, and what are the terms?
Hillary?
If I can get it unmuted. Ms. Beasley, do you have the paperwork there in front of you?
I do. We're doing a plea to CR 21-00136, Judge. And the two other cases, which is an ag assault, I believe that's CR 21-182, and a DWLI, which is 2021-00375, will be 1245 to this.
All right. So tell me that 1245 again.
1245 will be CR 21-00182. That's an ag assault case.
Yes, I have that one on the docket. Did you say there was another one?
There is a misdemeanor DWLI 2021-00375.
375 DWLI. Okay, that's the one I don't have on my docket. Okay. And what are the terms for the sexual assault of a child charge?
Yes, sir. We're pleading guilty. He will receive 4 years TDC, $2,000 fine, $290 court costs, $35 reimbursement fees, 128 days back time credit. And we've made an agreement in regards to a protective order on this case.
Okay, and has Mr. Ogletree been served with the notice of the state's application for protective order?
He has, Judge. I've gone over the application with him for the protective order itself. Just to let the court know, Hillary and I have talked about it. There is a condition that he's supposed to take a class and send an affidavit into the court, but the DA's office has agreed to waive that condition in the order. But I've X'd it out at her request. I've also initialed that paragraph along with my client. There is also a condition that he's supposed to turn over his firearms in his possession. He doesn't currently have any in his possession because he's in the jail. But any guns he has, he's going to release those to family because he understands he can't be in possession of guns from here on out.
All right, and Mr. Ogletree has been provided a copy of Chapter 62. Is that right?
That is correct, Judge. I physically handed it to myself. He and I talked about it several times. He's requested a copy and he got it today.
Okay, and let me repeat the plea agreement back so that I'm certain. So it's going to be a guilty plea to sexual assault of a child, 3 years TDC, $2,000 fine.
4, Your Honor. Sorry to interrupt. 4 years TDC.
4. Okay, I heard 3. 4 years TDC, $2,000 fine, $290 court costs, $35 reimbursement fees, 128 days credit towards that 4-year sentence. 1245, the ag assault deadly weapon, CR 21-182, and the DWLI 2021-375.
That is correct, Judge.
And then there's an agreed protective order in FM 21488, correct?
That is correct, Judge. It expired June 13th of 2023. if he's been released from prison by that date. If however he's still in prison, it will extend and expire on the first anniversary after he has been released.
All right, thank you, Ms. Beasley. All right, Mr. Ogletree, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Mr. Ogletree, your name is Philip Andrew Ogletree, is that correct?
Yes, Your Honor.
And sir, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Ms. Debbie Beasley. Are you pleased with her representation of you?
Yes, Your Honor.
You feel like you've had enough time to discuss all of your cases with her and have all of your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And have you signed on each paperwork your true and correct signature?
Yes, Your Honor.
Ms. Beasley, have you explained to your client his legal and constitutional rights?
I have judged both in respect to the protective order as well as the new case. He understands everything and agrees to everything.
Thank you, Ms. Beasley. And you do believe him to be competent today?
I do, Your Honor.
All right, Mr. Ogletree, in CR 21-136, you have been charged by indictment with a second-degree felony offense of sexual assault of a child. If convicted by a court or a jury, your sentence would have to be within the legal range of the minimum 2 years to the maximum 20 years confinement in TDC and a fine of not more than $10,000. And the other case is being 1245, so I'm not going to go over the range of punishment in that. And so you've heard Ms. Beasley and Ms. Heisel discuss the plea agreement in your case. Is that your understanding of the plea agreement today?
Yes, Your Honor.
And you've also heard discussion about the agreed protective order in FM 21-488. And is that your understanding of the agreement in that case as well?
Yes, Your Honor.
All right, then to the charge of sexual assault of a child, Mr. Ogletree, how do you plead?
Guilty.
And are you pleading guilty because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Ms. Beasley, objection to States 1 stipulation of evidence.
No, Your Honor.
States 1 will be admitted into evidence, and the court will take judicial notice of Mr. Ogletree's judicial confession. State, at this time, will you give me two things, the facts supporting the plea, and then I need to know about victim notification.
Yes, Your Honor. I'll start with the facts. Mr. Ogletree is a 29-year-old man who was engaged from July of 2020 to September of 2020 in a sexual relationship with a 15-year-old resident of Van Zandt County. Some of the occurrences, some of their relations occurred in Kaufman County, some occurred in Van Zandt County. They were ultimately discovered by the victim's parents, which led to a law enforcement investigation. Mr. Ogletree confessed to law enforcement that he had been undergoing a sexual relationship with this 15-year-old and that he was aware of her age at the time. And so that is how the sexual assault violations got filed in our county. As for victim contact, we have victim impact statements from both the victim and her mother, which I believe have already been forwarded to the court via Ms. Taberham. We would ask you to take notice of those right now before pronouncing sentence, Your Honor.
All right, Ms. Beasley, any objection to the factual summary?
No, Your Honor.
All right, and I do believe the victim impact statement was provided. Let me see if I can find it here.
Your Honor, if I may,
Yes, ma'am.
address Faisal. It's my understanding, since my client has been in custody, that your victim in this case has, through third parties, contacted my client. And I would ask that the DA's office, especially since he is under this protective order, contact the victim in this case and advise her to no longer contact my client, regardless of where he may be.
We will reach out to them after the plea when we serve them a copy of the protective order, and make sure that that's communicated.
Thank you.
All right, the court has reviewed the victim impact statement. Court will take that into consideration and will also sign the victim impact statement tracking form for return to the Van Zandt County Criminal District Attorney's Office. Anything further from the state or the defense?
No, Your
No,
Honor.
Your Honor.
All right, then based on the evidence, the court will follow the plea agreement reached in this case between the defendant and the state. CR 21-136, the state, or the court rather, convicts Mr. Philip Andrew Ogletree of sexual assault of a child, assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice, orders him to pay a $2,000 fine, $290 court cost, $35 reimbursement fees. Court awards him 128 days credit towards his sentence for the time that he has already spent in jail on this cause. Court will take into consideration and dismiss under section 1245 of the Texas Penal Code, cause number CR 21-182, aggravated assault with a deadly weapon, and cause number 2021-375, driving while licensed invalid. Court will find that this is an offense under Chapter 62 of the Texas Code of Criminal Procedure, and that Mr. Philip Andrew Ogletree will be required to register as a sex offender for the remainder of his life. With regards to civil cause number FM 21488, the court will find that the state of Texas has filed an application for a protective order. Court will find that the state and the defendant have entered into an agreement after Mr. Ogletree has been served a copy of the protective order, and the court will approve the final protective order in this matter, and the court will sign that for filing.
And Your Honor, just for the court's information, the date on the date of expiration of the protective order is the victim's 18th birthday.
Thank you, Ms. Heisel. I do appreciate that. All right, Mr. Ogletree, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you go over with the bailiff, be fingerprinted. Good luck to you, sir.
Thank you, Your Honor.
You're welcome. So state for your record purposes, not my record purposes, CR 2184, Larissa Marie McMillan has not appeared. So I've got that under advisement for 20 more minutes. So I know you can look shocked. And so at the expiration of 20 minutes, the judgment in I would no longer be under advisement, and the court will issue a warrant for her arrest.
And Judge, I will be over to the courthouse shortly. I think that we got everything signed, but I'm usually wrong about that. So I'll make sure I come over before I head out of town to make sure everything's signed.
Yes, ma'am. Thank you.
There are blanks.
I will call your mom, okay?
All right, I believe that does conclude our afternoon docket. Deputy McLeish, are you aware of any other inmates that we have missed, or if there's a further need for me to stay online.
No, Your Honor, the room is empty.
Thank you for your hard work today. Thank you, Mr. Hard work as well. All right, we will be adjourned and we will resume same time, same channel.